Okay, welcome everybody. Thank you for coming. Thanks to those of you who are joining online. We're going to be talking about the Trump indictments today. I think the order of ceremonies is that, let me introduce ourselves. My name is Jonathan Witmer-Rich. I'm a professor and co-director of the Criminal Justice Center here at the Cleveland State University College of Law.
And I'm Abby Moncrieff. I'm a professor in law and political science at Cleveland State and also the co-director of the Center for Health Law and Policy, which is relatively irrelevant to today's panel. But I teach constitutional law, so I'll be presenting some conjectural defenses that Trump might raise to the criminal indictments. The only one that he has filed so far is the defense in the state of New York's case. So my role will be largely guesswork, but educated guesswork.
So, a lot of this is going to be guesswork, frankly. I saw a great statistic recently, which is that throughout United States history, American presidents have faced an average of 1.5 felony charges, which is 0 for everyone else and 91 for Donald Trump. So we are in new territory, and there's a lot of, who knows what's going to happen down the line. The structure of the program, we're going to go one by one in chronological order, starting with the New York indictment. I'll try to give a brief summary of the nature of the charges and the allegations for the indictment. Professor Moncrieff will make a few comments about her thoughts, like she said, about possible defenses for each case. And we'll try to go through all 4 cases in order. We will then have time for Q&A, hopefully a pretty good amount of time. Those of you online are welcome to type in questions, and we'll try to turn around and take a look at them and see if we can read them and answer those. And we'll also have opportunity for those of you in the room to ask questions as well. So, first indictment, March 30th, 2023. Trump is indicted in the state of New York on 34 felony counts of falsifying business records. So this is an interesting case that I've described as kind of seems factually pretty solid and legally highly uncertain. So the factual allegations, there seems to be a lot of evidence supporting them, including the fact that Michael Cohen, who's at the heart of those allegations, has already pled guilty to and served time on, a federal campaign finance violation for doing exactly what is alleged in the New York indictment. It's also pretty clear that what happened there were at the very least misdemeanors under New York law, but charging the case as felonies in New York is what is the real stretch. So just really briefly, the factual allegations here are that Donald Trump allegedly has an affair with Stormy Daniels back in 2006. And in 2016, during the presidential campaign, the National Enquirer purchases her story for $130,000 and does so in collaboration with Donald Trump and his lawyer, Michael Cohen, for the purpose of killing it and not getting it published anywhere. So one of Trump's lawyers, Michael Cohen, eventually pays Daniels the $130,000. And then eventually in 2017, Trump pays Cohen $420,000 to cover the cost of that payment, plus taxes that Cohen had incurred, plus kind of an extra fee for facilitating the transaction. And the payments to Cohen, Trump records as legal expenses, on the premise that he's paying him for legal services, but in fact, that is alleged to be false. Those payments were in fact expenditures on behalf of the Trump campaign, really made in an effort to help reelect Donald Trump, and therefore should have been disclosed as federal campaign contributions to Trump's campaign. So the New York State issue, what are we talking about? Well, it's the misrepresentation, misclassifying, something as something else on the record books of Trump's own businesses that are at least misdemeanors under New York law. So falsifying business records, a misdemeanor. The more aggressive part is charging this as a felony. So for falsifying business records under New York law to be a felony, it has to be done with the intent to commit or conceal some other crime. So it's not clear what that alleged other crime is precisely. And strangely enough, under New York law, the prosecutor does not have to specify in the indictment, even when he's charging it as a felony, what the other crime is that the person is alleged to have committed. So that's established under New York law. Very strange, and clearly something that, seems to me unfair to defendants and can be abused by prosecutors. One possibility is the federal campaign finance law violation, which seems there's a strong case occurred, but it's extremely unclear under New York law whether violation of a federal law counts as an other crime for the purposes of turning a New York falsifying business records misdemeanor into a felony. There are some other possibilities as well, maybe a New York campaign finance violation, but it's unclear whether doing this in a federal campaign would violate the New York campaign finance laws. So there's a lot of uncertainty legally in the case, even though factually, I think there's, a good bit of evidence that this in fact occurred.
Yeah, so actually, I think there are subtleties to the uncertainty in ways that implicate the Constitution. So let me try to this is the most complicated case, constitutionally speaking and legally speaking. The other ones are fairly straightforward. So as Jonathan said, the key is whether the state of New York can elevate a misdemeanor to a felony on the ground that the falsification of business records was done with the intent to conceal some other crime, where the other crime is a federal crime rather than a state crime. And so it's really, really obvious that if the $130,000 was a campaign contribution, that it was a criminally large campaign contribution, because the Federal Elections Campaign Act, which is a federal statute, puts limits on how much you can contribute to a national campaign, to an election campaign. And $130,000, way over any of the limits. So the idea is there's an obvious crime having been committed if the $130,000 is factually a campaign contribution under the Federal Elections Campaign Act, but there's a constitutional federalism problem with having the state of New York prosecute Trump for committing a federal crime. Typically, states can't prosecute you for federal crimes. Federal prosecutors have to prosecute you for federal crimes. And so the question is, if the intent to commit a FICA violation is an element of the state crime, constitutionally speaking, can New York use that, given that they're not actually prosecuting Trump for having committed a campaign violation under the Federal Elections Campaign Act? They're not actually charging him with the federal crime. They're just saying you falsified business records under state law with an intent to conceal your criminal activity at the federal level. So it's not actually a state prosecution for a federal crime. It's a state prosecution for a state crime that has as an element the intent to conceal a federal crime that had already been committed. And so far, one judge has ruled on this aspect of the case and has said that the state of New York is allowed to pursue this theory using a violation of the Federal Elections Campaign Act as the other crime that he was intending to conceal, for the reason that I just gave, which is that New York is not in fact prosecuting him for the crime under FICA, but is instead just using the intent to commit or conceal as an element of a state crime. Okay, does that make sense? So it's roundabout and complicated, but the idea is that the federal crime is not actually being prosecuted by the state court, so it's okay. The second possibility is there's a New York statute that says that you're not allowed to promote somebody for election using unlawful means. And the unlawful means can be unlawful by state law and not federal law, even in the context of a federal election. So New York specifies that their state election laws apply to federal elections. So then this state statute that says you can't campaign for somebody using unlawful means, which is pretty vague, applies to, allows all state laws to apply even to federal elections. But then the constitutional question of whether the state legislature is allowed to regulate federal elections, given the presence of the Federal Election Campaign Act, is whether the Federal Election Campaign Act preempts state law and makes the state law basically null. because the federal law trumps it. It's under the supremacy clause of the US Constitution. If two statutes conflict, one federal and one state, the federal law wins. And so here we have a federal law and then a state law. And the question is there conflict between them, or can they coexist peacefully? And again, so far we have one ruling from a district judge in New York saying he doesn't think that the preemption defense is going to go very far, even if the state uses this state law, this like very vague state law, as the other crime that's being charged in order to make it into a felony. Although it's not actually being charged, it's just being raised as an element. The intent to conceal a crime of having campaigned for Trump using unlawful means. Okay, so the reason that they said that this is not preempted is that the federal judge looked at FECA preemption under case law and said that the Federal Elections Campaign Act does not trigger what's called field preemption. It doesn't try to occupy the whole field of campaign finance regulation or elections regulation, and that there are certain things that states are still allowed to do, even with the Federal Election Campaign Act in place. And so it is the preemption effect, the preemptive effect of the Federal Elections Campaign Act is limited to 3 categories. I won't get into the details, but it doesn't include this particular New York statute that says that it's illegal to campaign for somebody using unlawful means. Okay, this is like super technical. Does any of that make sense to you guys? Are you following it? It's hard to follow without like seeing the statutes in front of you and looking at like the language of them. But basically, so far, the federalism problems with the theory have all been rejected. And so this theory for elevating from misdemeanor to felony seems to be flying so far. And Jonathan said it's like legally a risky case. To my mind, I think it's legally risky only because there's no precedent, not because it's actually a bad theory. I think it's actually a fine theory. I think it's actually a pretty simple theory and like should work out just fine. But because it's new and novel and no court has ever addressed it before, everybody's nervous about it. And that's law, right? Like anytime a new thing comes up and a court hasn't already ruled on it, people are going to be like, well, I don't know, should this be what it is or should it not be? And like, even if textually or theoretically, it's all very straightforward, people are still going to get a little antsy about something that doesn't have prior case law deciding it. So just looking at it, because under the New York law, it's just the intent to conceal the crime and not the actual commission of the crime that matters. I think it's fine for New York to use the intent to conceal as an element, even if the crime that's being concealed is a federal crime. And as the judge who has ruled on it so far in the federal district court said, even if there was no crime actually committed under federal law, the intent is what matters. And so there doesn't actually have to have been a crime even, much less proof of a crime or like conviction for a crime. It's just the intent to try to conceal it. And so therefore the federalism issue should be like non-prohibitive for this particular theory, I think. That's as far as I know. Oh, the only other constitutional theory that Trump raised, and I'm laughing because the judge was hilarious in dismissing it. And like all the judges who have thought about this so far have been like, what? He tried to say that he gets immunity for it and that he should be allowed to remove the case to federal court rather than being in state court because he was acting as president of the United States when he paid Michael Cohen. So by the time he paid Michael Cohen, he had already been elected and was acting as president. So all of the statutes that relate to this, including the federal removal statute, require not only that you be president, but also that the thing you do be presidential, that it be sort of under the color of your duties as president of the United States. And all of the judges have been like, paying hush money to your porn star is not a presidential act. I can't believe I have to put this in writing. But he is trying to argue that as president of the United States, he gets immunity. And he's kind of, I think his theory is very Trumpish theory that, well, everything I do is official and deserves to be protected from scrutiny because I was president of the United States and I'm Trump. But I don't think that theory is going to get anywhere.
All right, let's jump to the next case. So by June 8 of 2023, Trump is indicted by a federal grand jury. Now we're in federal court on 37 counts, now 40 counts, mostly willful retention of national defense information in violation of the Espionage Act. So this is the classified information kind of national defense information case. And so essentially what happens here, just briefly, right, is that Trump leaves office in January of 2021. And by May, the National Archives and Records Administration, NARA, N-A-R-A, realizes that they are missing some records from the Trump administration. So they ask Trump repeatedly to please hand over their records. And they also say, we'll refer this to the DOJ if you don't. So in January of 2022, so 6-7 months later, Trump returns 15 boxes of documents to the NARA, and they learn that the boxes include classified information, and so they notify the Department of Justice. By May of 2022, a federal grand jury issues a subpoena to Trump to return any remaining classified documents. In June of 2022, Trump certifies that he has returned all classified material. Then in August of 2022, after developing probable cause that there still was classified information at Mar-a-Lago, the FBI gets a search warrant and executes a search warrant at Mar-a-Lago and seizes over 13,000 documents, over 300 of which were allegedly classified, including some that contain national defense information. And so the indictment says that the 31 documents, describe U.S. nuclear weapons, foreign military attacks, plans and capabilities, foreign nuclear capabilities, foreign support for terrorist activity, communications with foreign leaders, U.S. military activities, and other kind of important stuff. It also alleges that they have recordings of Trump kind of talking with reporters, writers about this and pointing out that this is still classified. I could have declassified it, but now I can't because I'm not president anymore. So, the charge there is whoever, having unauthorized possession of documents related to the national defense, which information the possessor has reason to believe could be used to the injury of the United States or to the advantage of any foreign nation, willfully communicates, delivers, or transmits, or attempts to communicate, deliver, or transmit that information to any person not entitled to receive it, or who willfully retains that and fails to deliver it to the United States, is guilty of an offense and can be imprisoned up to 10 years. So that's basically the charge there. And here, this one seems relatively straightforward to me. There seems to be a great deal of evidence. We'll see how it all plays out, right? But there seem to be, video, some audio recordings, photographs of where the information was held, the documents themselves when they were seized, and it seems to pretty plainly fall under the scope of the act. I think the main issues here are people, questions about should we be spending our time charging a president with something like this, or is it not worth it?
Yeah, no, I think this one has the least constitutional law possible in it also. So I think the one thing, there are two things that to a non-lawyer, I think are going to seem like plausible defenses, and to a lawyer, they're just not. And I know this because my husband and I have talked about it, and he's not a lawyer, and he's like, well, I don't understand, why should this not? So the one big thing is, and Jonathan alluded to it, Trump did have the authority, even the sole authority under the Constitution, to declassify the documents when he was president of the United States. He could have just erased the top secret from the top of all of the documents before he took them home, and then there would have been no crime. And there would have been absolutely nothing anybody could do about it, because he had authority as commander-in-chief to decide what's classified and what's not. But he didn't do that. And so then by the time he wanted to, he wasn't president anymore and didn't have constitutional authority anymore. He left the office and was stripped of all of the powers given to the executive branch of the United States government the moment that he got elected out of office and left the presidency and Biden got sworn in. So then at that point, if he retains documents that he did not declassify when he had the power to declassify them, then he's committing a crime, even though he could have declassified them the day before he left the presidency, and then there wouldn't have been a crime. So he can't claim, well, because I used to have the authority to declassify these documents, I should be allowed to keep them or decide in my discretion that they're keepable by a private citizen, given that he no longer has that constitutional power. So to a lawyer, this is like brain dead obvious, like, yeah, that's not a good defense. You do not have executive immunity or any claim to executive privilege or power or any kind of constitutional defense to having kept classified documents once you left the presidency, even though you could have protected yourself from this problem if you had just thought about it ahead of time. And then the second thing that I think is really obvious to a lawyer, but maybe not so obvious to non-lawyers, is that he might be able to argue something like malicious prosecution based on the fact that both, well, all of Hillary Clinton, Joe Biden, and Mike Pence have been found with classified documents or classified information improperly stored in some way on their email server in Hillary's case, and as hard copy documents at home in Pence and Biden's cases. And Trump is the only one being prosecuted. So he could say, listen, there's like this really clear pattern right now of me being the only one targeted for prosecution under the criminal laws of the United States for having done something that lots of public officials do all the time. And the problem with that from a lawyer's perspective is that when asked to hand back over the classified materials, all of the other people that I just named have cooperated fully, handed back all of their classified documents, made no efforts to obstruct the investigation or request to turn them back over to the FBI or to the National, what was it, NARA, the
Archives and Records
Administration. Whereas Trump did obstruct and try to keep hold of the documents even after being asked to turn them back over. And so if you look in bigger picture, look at the cases in which people have been caught with classified documents and have not cooperated, all of them get prosecuted, like 100% of the time. It's only when you cooperate quickly and readily and hand back over the documents that you don't get prosecuted. So in fact, Trump is not special in any way in the grand scheme of cases involving classified materials. He's being prosecuted because he behaved the way that everybody who gets prosecuted behaves. And the people who don't get prosecuted have behaved quite differently. But it is a slight factual nuance in his case that it's the obstruction efforts and the non-cooperation that's gotten him in trouble and not the retention of classified documents in the first place.
And as I said, the statute requires, willfully retain the information. And the U.S. Supreme Court has interpreted the word willfully in general under federal law as a very high mens rea, right? So you really have to kind of know what's going on and do it deliberately and all of that kind of thing. And that's, in line with Abby's point, where folks who have the information and turn it over when asked, the prosecutors tend to say, okay, you're not willfully, retaining this information, but that doesn't seem to be the case here. Okay, let's move to indictment number 3. Now we're in August 1st, 2023. Now we have the federal indictment related to the conspiracy to kind of overturn the lawful results of the election. And now we only have 4 counts, right? So the other ones kind of have a lot of different counts. They involve, every time you made a false entry or every time you did this. And here they're just 4 very broad conspiracy counts. So one count is a conspiracy to defraud the United States, which is a federal statute, using dishonesty and fraud to impair and obstruct the lawful process of counting and certifying the results of the presidential election. 2 counts of conspiracy to obstruct vote certification procedures, and 1 count of conspiracy to violate civil rights, in particular, the right to have your vote counted. And so this indictment really lays out the government's view of the full scope of what Donald Trump and others with him were trying to accomplish that culminated in January 6th, but had a lot of moving parts before that. So paragraph 7 of the indictment says it kind of broadly, quote, the purpose of the conspiracy was to overturn the legitimate results of the 2020 presidential election by using knowingly false claims of election fraud to obstruct the federal government function by which those results are collected, counted, and certified. And the indictment talks about specific false claims, and it says specifically, quote, "These claims were false and the defendant knew that they were false." So now we're getting into what did Donald Trump know about what was going on. I do think it's important to clarify between, does Donald Trump in some metaphysical way truly believe that he won the election? That's not really what's at issue in this indictment, I don't think. It's rather, was he making specific claims that he knew were false in the course of trying to overturn the results of the election, right? Like that's a little bit more narrowly what the indictment charges, right? So, for example, organizing slates of fraudulent electors, right? Like alternate electors in 7 different states and causing them to meet and cast their votes. So, and submit their certification to the relevant federal authorities to try to have documents of, okay, we have a disputed election here, right? We've got 2 different set of electors and somebody's got to decide, and who's going to decide, well, Pence will call it, or the House of Representatives will get involved or whatever. And notably, one particular allegation is that some of the fraudulent electors in these states were tricked into participating by specific representations that the only, we need you to vote here on this, alternate slate saying that Trump won, but we're only going to use this if we win our lawsuit proving that there was fraud in the election. Then we preserved this alternative by having this here. That's the only way we're going to use it. That's, of course, not what they did, right? They presented it as a legitimate alternate slate of electors. So there's kind of a specific false representation there that's belied by what actually happened later. So, this one, again, it's less kind of specifics and really the big picture of an attempt to kind of subvert the results of a legitimate election. So it's telling the big story here, I think.
Yeah, the constitutional difficulty with this one, and this one and Georgia are pretty similar. So we may end up. Actually, do you want to, maybe we should go ahead and present Georgia.
I'll quickly present Georgia because it really is the same story, right? So now it's the state of Georgia, August 13th, charging 13 felony counts against Donald Trump, 18 co-conspirators, including Rudy Giuliani and other, attorneys and so forth. And essentially it's a conspiracy to overturn the 2020 presidential election, the same basic set of facts described in the federal indictment. Under Georgia law, it's being charged, the big charge are RICO violations, the Racketeering, Influenced, and Corrupt Organizations Act, which started at the federal level and was pioneered, of course, by Rudy Giuliani when he was the U.S. attorney in New York, and has been adopted by many states. And so Georgia has a version of the RICO statute. And what is RICO? RICO was kind of designed to take down organized crime, right? Criminal organizations. And the structure of it is that if you can show that the people committed a pattern of what might be relatively minor offenses, but it's a pattern, and they did so for the purpose of committing a broader, criminal goal, then it becomes a serious offense, a RICO offense. And under Georgia law, the statute says that the punishment is 5 to 20 years in prison. I think my understanding is that a Georgia judge has the discretion so you have to impose 5 years as a minimum, but you can suspend it and allow the defendant to serve probation for it. So I don't think it's actually a hard mandatory minimum. And so essentially, right, it's the same story, primarily focused on Georgia, right? Pressuring Georgia election officials to violate their oaths of office by not doing what they're supposed to do, for example. And it includes the kind of infamous call to the Georgia Secretary of State, where he's asking him to find him 11,000 more votes. And so that's, the Georgia version of the same case, basically.
Yeah. So did you guys follow enough of the news around the election to know what all these different factual elements are? So I was just talking to Keith right before we started, and he was like, "Am I gonna be able to follow this even if I haven't been following the news?" So let me like recount a little bit of the story of what Trump actually did so that we have a better understanding of, because the constitutional claims are going to depend heavily on exactly what Trump did and what he thought he was doing and what he believed he was doing throughout the entire process. So, he lost the election in November by small margins in a number of states, but a lot of those states actually changed the result after mail-in ballots came in, because we were in the middle of COVID. So a lot of people, way more than usual, voted by mail rather than standing in line at the election at the polling places to cast their ballots. And so as a result, some of those returns didn't get finalized until a significant time had passed from election night. A couple weeks later, we finally had all the mail-in ballots counted and we knew who had won in some of those states. And so Trump was watching this process unfold and believing, maybe sincerely, but certainly incorrectly, that what was actually happening in those states that were counting the mail-in ballots was that the election officials were manipulating the counts and trying to rustle up more Biden votes, or lying about who had won, or tampering with the machines to try to get them to show greater margins for Biden or more votes for Biden or something like that. So Trump was watching all this unfold, thinking this is something fishy is going on. Some of these mail-in ballots are fraudulent. Some of these election officials are manipulating the systems and making it look like Biden won, when in fact I really won, because on election night it looked like Trump had won. And so he started trying to combat what the results looked like through a number of strategies, including recruiting his own electors. So under the Constitution, we don't actually vote for president. We vote for electors who then represent us in the Electoral College. And the Electoral College is what actually elects the president of the United States. So when we cast our ballots, even though we mark on our ballot we want Trump or we want Biden to be president, we're not actually voting for Trump or Biden. We're voting for the electors who will then go vote for either Trump or Biden in the Electoral College. So Trump tried to recruit alternate electors. So the state of Georgia, which states were they that he tried to get?
Georgia, Michigan, Arizona, I forget the others.
Yeah, I'm forgetting the list. But so there was a handful of states that had narrow margins for Biden. Pennsylvania, okay. And Trump went to those states and said, well, if we can just put together an alternate slate of electors, not the ones that are officially have been hired by the state government, but instead to go and vote in the Electoral College, but our own guys who know that I won and that Biden didn't really win and that this count is fraudulent, we send our own electors to the Electoral College, then they'll vote for me and I will win the presidency, because really it's the Electoral College that votes and not the people. So he put together these slates of electors, had them sign a bunch of forms saying this is our official vote and we're certifying our result for the Electoral College, voting in favor of Trump. Now, that was obviously fraudulent. And as Jonathan said, some of these lies don't depend on what he really believed in the grand scheme of things. Did he sincerely believe that he won the election? Maybe. Did he sincerely believe that the people he had recruited to represent him in the Electoral College were the legitimate electors for the state of Georgia? No. He couldn't have. His whole purpose was to create a separate set of electors. And it is a crime to impersonate a state official. So if you go to the Electoral College and say, I am the legitimate elector for the state of Georgia, but in fact you're not, you are just a lackey that Trump has hired to go pretend to be an official elector for the state of Georgia, then you're committing a crime whether or not you believe that what you're doing is really representing the true vote of the individuals in Georgia who cast their ballots in the presidential election. So the electors themselves the fake electors were fake electors, whether or not they were accurately representing the voters in the state of Georgia. That's one piece of what he did. Then he also got up on stage on January 6th, which was the day that the Congress, the Senate, was supposed to certify the election results. After the Electoral College had voted, said Biden wins, the Senate had to gather, convene, certify the results, certify Biden as the proper president-elect of the United States. And the Vice President Pence, had to sign off on Joe Biden having been elected president of the United States. So on January 6th, Donald Trump got up in front of a big crowd of supporters in Washington, D.C., near the White House, and gave a speech in which he again refused to concede, repeated his claims of election fraud and claims of having won the election, and used very careful language to encourage his supporters to march to the Capitol and resist the certification of the election. He called on Vice President Pence to refuse to certify the election results, but never said, let's go tear the place down or do anything violent. And so there was a possibility of charging him with inciting an insurrection that Jack Smith, who is the federal prosecutor, chose not to pursue because he had spoken so carefully. Sometimes Trump seems like he's completely unfiltered, but then you look at the words that he actually chooses for some of the things he says, and it's like he's a very calculated, unfiltered person. So he was extremely careful not to say, let's go snag Mike Pence and Nancy Pelosi and, hang them in the public square, which is what his supporters understood him to be saying. And instead to say, let's march peacefully and protest and demonstrate, but fight like hell. But metaphorically, maybe that doesn't mean actual like fisticuffs. So then the elements of the conspiracy that have to do with interference with an official proceeding in Congress might be hard to prove because he was so careful about what he said that like Trump maybe wasn't responsible for the march on the Capitol. So again, back to the facts, like what actually happened was all of these supporters marched to the US Capitol building, broke windows, busted through doors, went into the Capitol, beat up some police officers. I think 3 people died, and went on a hunt for Nancy Pelosi and Mike Pence to try to prevent them from certifying the election results. They caused a bunch of damage. The Senate shut down. Pence got swept off into the basement of the Capitol building and protected there so that he wasn't harmed. But lots of property damage done. And the Senate had to hold off on certifying the election results until I think like 1 or 2 in the morning that they finally got it done. So then the question of whether Trump is responsible for that obstruction of the official proceeding might be slightly difficult because Trump was so careful about what he said when he was encouraging his supporters to go to the Capitol. He did not encourage them to obstruct in so many words, and yet he obviously encouraged them to obstruct. But he was just careful about how he did it. Okay, so now how does any of this relate to constitutional law, constitutional defenses that Trump might raise? In both of these cases, I expect that he is going to forcefully assert a First Amendment barrier to prosecution. He's going to say, you can't come get me for just thoughts that I had, things that I said. My electors were going forward by way of protest. They weren't presenting themselves as official electors. They admitted that they were alternate electors all along. And they were there as a form of protest to the official electors, the official slate of electors that had been certified by the state of Georgia. This is political speech strongly protected by the First Amendment to the Constitution. He might also say that his speech in Washington, D.C. on January 6th is 100% protected, that there is nothing about it that can give rise to criminal prosecution because all of it was verbal. There was nothing about that speech that took the form of a fraudulent slate of electors, a more active form of crime. It was all just ideas, thoughts, spoken word that may be protected by the First Amendment. Now, there are lots and lots of exceptions to the freedom of speech. The freedom of speech does not mean that you have a right to say whatever you want, whenever you want, immune from any legal liability, criminal or civil. There are lots of ways that you get in trouble for mere words. For all of you students sitting in the room, legal malpractice is usually committed through spoken word or written word doesn't mean that it's protected. And it all centers on ideas, but it's not protected by the First Amendment. You can get in trouble for committing legal malpractice. And Oliver Wendell Holmes famously said that the First Amendment does not protect your right to shout fire in a crowded theater. There are things that you can do that are so clearly dangerous that they can be punished by the state, even though they're accomplished through spoken word. And so the standard now is that the state can punish you for incitement to imminent lawless action. So if through your speech you incite somebody to imminent lawless action, then you can be punished for it. So with respect to the false slates of electors, he clearly incited people to behave lawlessly, to pretend that they were electors, to submit paperwork that looked like they were impersonating state officials. And Trump incited them to do it. So it seems like that should be outside of the scope of First Amendment protection, unless he can claim that they weren't really representing themselves as state officials, that they were just engaging in a form of political protest, in which case maybe the First Amendment creates a barrier. But then with respect to marching on the Capitol, again, because he was so careful in what he said, it's going to be hard to prove that he falls outside the scope of the First Amendment when it comes to inciting the obstruction of the official proceeding. They didn't say, they didn't use the insurrection, the incitement of insurrection crime. They instead did obstruction of an official proceeding, which is maybe a little bit lower bar First Amendment wise, but and in particular, conspiracy to obstruct it. Conspiracy not actually obstructing it, but right. So so again, and then all conspiracy statutes have a First Amendment dimension to them because conspiracy is planning, it's not action, right? And so anytime you're just planning, you have an idea of committing a crime and you're collaborating with other people about committing the crime. The idea is what's being punished as opposed to the action of actually committing the crime. So I ultimately, I think the First Amendment won't be a barrier, or at least it wouldn't be a barrier in front of any U.S. Supreme Court that has existed prior to the one we currently have. The only thing that I don't know is whether this particular Supreme Court with its new 6-3 conservative majority that has been expanding First Amendment rights is likely to push the Constitution in the direction of like really, really robust protection, even for what would ordinarily have been considered obvious crime without First Amendment barriers to it. So yeah, the big question mark is just the new court. But prior to this court, I would have said these are, there's a plausible First Amendment claim, but ultimately it fails. With this court, there's a plausible First Amendment claim, and I have no idea what's going to happen with it.
All right, let's go to Q&A. We've talked enough. We've got about 15 or 20 minutes for Q&A. Bob, would you mind carrying the mic around? Folks who are online, you're welcome to type in a question. Hopefully we'll be able to see it and we'll try to respond. Any questions from anybody in the audience?
Professors, thank you for doing this. My question is, and I'll try not to betray any like political ideology here, but how do I separate my personal animus towards a person and his character and his policies from an objective and impartial analysis of the illegality or legality of what he's done? And when I look at these cases, I find it very hard for me to look at them objectively because of how I feel about Donald Trump as a person and as a president. And I think one of the frustrations about being a law student is that we're almost more ill-equipped to understand this stuff because we can recognize that it's far more complex than what's being presented to the American public, but we lack the tools to fully understand that complexity. So it's kind of this double-edged sword where I'm almost more confused by it than my friends and family that are not in law school. And so I guess this is a solicitation of advice of how do I look at these charges in these cases and assess them objectively in light of my own personal political feelings about it?
Yeah, that's a great question.
I mean, my gut reaction is don't work too hard at that. Law is never as divorced from feeling as we want it to be. Aristotle once said, law is reason free from passion. That's bullshit. Law has a huge amount of passion involved in it. And the ways that judges decide cases are always going to be inflected by their personal biases. That doesn't mean that all law is just politics and just bias. There is real law there too. But anytime you're in a legal gray zone, you have wiggle room to push it in one direction or another based on how you feel about hopefully based on how you feel about the policies that are infusing it, hopefully how you feel about the collective good, the collective well-being, the importance of ensuring that people who get elected president of the United States have the character required to perform the job, and not just individual animus of like, well, Donald Trump has dumb looking hair, so I want him to go to jail. That's not okay. But Donald Trump is unfit to be president of the United States for a whole host of reasons is not an illegitimate reason to think we should maybe push the law in the direction, in my view, is not an illegitimate reason to push the law in the direction of he should be charged and convicted of these crimes. And that doesn't mean that this is a witch hunt against conservatism or republicanism. It's just that Donald Trump as an individual did not behave in a manner that is consistent with how we think presidents of the United States or former presidents of the United States ought to behave. So my initial thought is don't go too far in the direction of suppressing your instincts or your feelings or your emotions about law and policy, because those things can and should infuse your practice and your understanding of what's good for the country as a whole. But you don't want to be completely biased against individuals either. So, I think it's a balancing act.
And I do think that even the exercise we're engaged in here, right, which is just trying to look at what are the factual allegations, what's the law say, right? I mean, when you read the National Defense, the Espionage Act statute, take a look at the elements, right? Try to look at the elements and say, does that really line up with what happened here? The New York case, as we talked about, has some legal uncertainty to it. The Espionage Act one seems pretty straightforward to me, and it's primarily, I guess, a question of is this a good exercise of prosecutorial discretion? But, it seems like they've got the evidence and it seems like they've got the law. So then, that's certainly a deeper level of analysis than most of the news stories go to, even if it's not getting every single possible wrinkle, but just even looking at the statute, what is he charged with? Does it look like that's what happened here?
Well, and as trained lawyers, you'll start getting frustrated with Google, because when you try to find a judicial opinion to read, that sometimes you just get inundated with all the news stories, and those are not good enough. And you want to read the actual. I was trying to find the denial of the notice of removal from the New York case. He's indicted and charged in New York. He wants to remove to federal court. A judge ordered, no, you can't remove to federal court. I'm trying to find that order. And it was very hard to Google. Eventually I got there, but through a series of Politico links. But related to what Jonathan said, one way to untangle some of that and work through the confusion is to go to the legal sources rather than the news sources. Those are going to be better.
Thank you for this as well. This is kind of more of a procedural question in terms of the criminal procedure. What are going to be some of the challenges if and when they try to seat a jury in these cases? Because obviously people know Trump. It's hard to not have an opinion formed about him going into any sort of voir dire, I guess.
Yeah, so they don't have to not know Trump. They just have to be able to render an unbiased opinion. That is Jonathan's area, so I'll let you in.
No, that's exactly right. So, and this comes up from time to time. This is a pretty big case, obviously, a lot of notoriety. But of course, there have been other cases in U.S. history, and there will be others where it's everybody in the country is talking about this particular case. And judges and the judicial system in general has sort of been somewhat insistent that we can try cases to a jury even when it's a big high profile case. You're going to have a really lengthy voir dire process where you're going to have hundreds of potential jurors being, screened, and some poor associate's going to have to read every single social media post that every single member of the potential jury has ever made, and right, and try to ferret out their biases. And but eventually they're going to seat a jury, and that's a possible grounds for appeal. Certainly that the jury wasn't unbiased, the voir dire wasn't done correctly, but it's been done before. It'll be done here.
Now, there's obviously a lot of cards that have yet to hit the table in these trials. Now, theoretically, if the RICO were proven in Georgia and similar trials in Michigan and Arizona for the false electors, at what point would the federal courts have to step in and say, hey, this is an organized thing? And then maybe at what point would the 14th Amendment possibly come into play there?
Okay, so you want to talk about the state versus federal and the removal issue in particular? So in general, right, when somebody gets charged in state court, they have no opportunity to move it into federal court. None of my criminal defendants have ever, right? In state, you're stuck with the venue that the prosecutor charges you in general. Now, this is a rare and unique exception to that, which is the federal officer removal statute. You want to speak to that a little bit?
Yeah, so it's a statutory jurisdictional quirk that when a federal official or a state official, I think actually, is being charged for a crime in a state court, they are allowed to remove if the conduct that gave rise to the criminal complaint was official conduct, which is why this paying your porn star is not official conduct point gets raised. So you have to be an officer of the United States engaged in an official act, being charged for acts that you undertook in an official capacity, and you have to be raising a federal defense. So there has to be a plausible federal defense to your crime. The federal defense could just be immunity, and then everything kind of collapses into a single thing. Like, you can't have immunity unless you're raising it as a defense to act undertaken as your official capacity while you were a federal officer, right? So it all kind of can be one thing if immunity is your defense. But there are other possible defenses, and in New York, the preemption defense, the Federal Election Campaign Act defense, is one possible federal defense that Trump could raise to the New York crime. But again, the federal judge that has ruled on it so far has said that doesn't fly. Now that's appealable. He'll probably appeal it to the Second Circuit, and it'll be a little while before we find out for sure whether he's going to be proceeding in state or federal court. But it looks so far like state court is going to be able to keep a hold of it. Now, I didn't follow the very last bit of what you said about the 14th Amendment. What was the question?
Oh, if the prosecutions in the various states pointed to similar, if not identical fact patterns, would it be therefore a federal crime if
No, it's a good question. But I mean, so for example, Georgia and the federal indictment in many ways are charging a similar crime based on similar acts. The U.S. Supreme Court just a couple of years ago reaffirmed the dual sovereignty doctrine, which is a doctrine, now we're thinking of double jeopardy, that you can prosecute somebody in state court and federal court, or two different state courts, for really the exact same crime based on the exact same act, because each actor there is viewed as its own sovereign. So the federal government's one sovereign, Georgia's one sovereign, Michigan would be another sovereign. They can each pursue criminal, even if it's based on the exact same facts. And, the Georgia and the federal, it's not really the same law, right? It's the Georgia RICO statute versus the federal conspiracy statutes. They're not really the same law, even though, but there's not really going to be any, the federal courts are not going to step in and say, we got to handle this all in one form or something. It'll go state by state, however it plays out.
Yeah, and so all of these are like multiple crimes between the federal indictment and the Georgia indictment. It's multiple criminal counts for one set of facts, right? And so it looks like, under the double jeopardy, where you can't be tried twice for a single crime, maybe he shouldn't be allowed to be charged in both places. But a single act can be lots of different crimes, right? So that's not double jeopardy. Double jeopardy is when the same forum tries you twice for the same act. So if I stand in one state and shoot somebody across the state line who's standing in another state, I've committed a crime in the state I'm standing in the state they're standing in, and as a matter of federal law, probably for crossing state lines in the commission of a crime. And so then I can be tried in state A, state B, and in federal court, all for just the one thing of pulling a trigger one time. But if state A fails to prove the case and the jury is hung or acquits me, that state can't try me again for that same act of shooting somebody, right? So double jeopardy only covers the same forum problem.
It looks like Professor Kalir online is making the point that, which is certainly very much Donald Trump's MO, which is he's going to try these cases in the court of public opinion as opposed to in the actual court. And he's asking, what are our thoughts on that? That's certainly, I'm sure he will try to do that.
Yes.
At a certain levels, when you can do that, but you are in court and you will get a verdict in that case.
And so far in New York, he's very much doing both. He's not shying away from fighting in the court and bringing the legal defenses he has available to him, and in fact asserting some quite aggressively that don't seem plausible, like arguing that the Federal Election Campaign Act preempts the New York law that is plausibly the thing that he's trying to conceal. That has already been decided not to be a valid theory, and he asserted it anyway. So he's pursuing legal strategies fairly aggressively. He's definitely pursuing political strategies very aggressively. It does raise an interesting prospect that is coming up in the news a lot, and that I meant to talk about as our overarching comments, that Trump, if he gets reelected, could pardon himself for the federal crimes. So he will have a pardon power that could excuse him from the 2 indictments that Jack Smith has brought, one for the January 6th and obstruction, and the other for taking classified documents. So remember, I said, it's really obvious to a lawyer that just because he had the power to declassify the documents when he was president doesn't mean that he had the right to keep the documents after he wasn't president anymore. But if he becomes president again, he can declassify those documents and maybe pardon himself. There's some uncertainty about self-pardons, but he may be able to pardon himself also for having taken the declassified documents in the first place. He certainly could pardon all of his co-conspirators for all of the federal conspiracy charges that Smith has brought against him. He cannot pardon himself for the New York or Georgia indictments because those are state crimes, and the president of the United States under the same dual sovereignty principle, the president of the United States has no power to pardon people for state crimes and state convictions. So in both New York and Georgia, he won't be able to pardon himself, but he could ask the governor for a pardon. And in Georgia, it's not totally implausible that Brian Kemp would pardon him.
My understanding is that the Georgia governor does not have a pardon power.
Oh, really?
Most governors, Ohio governor has a pardon power. We ask him for pardons in our pardon and clemency clinic all the time. But the governor of Georgia does not. So you have to serve your sentence. What that sentence would be is completely unclear. So I don't think, I'll just say, final thoughts. Timeline is extremely unclear here. Like how long are these cases going to take? When, if any, when will they go to trial? Completely unclear. And what, if convicted, what kind of a sentence would he get? I think also completely unclear.
Yeah, let me ask a related political question to your point. If you were someone that wanted to hold him accountable to impact the next election, or if you felt he was being railroaded and also wanted to affect the next election through vindication, so whether through conviction or acquittal, what's the strongest case? If you wanted to hold him accountable, which case would go first? And if you wanted vindication, what would you be thinking the first case would be?
I mean, to my mind, the one case that speaks most directly to my own personal objections to Trump as presidential candidate is the federal indictment for the January 6th obstruction. where I look at, that's the one that to me is most disqualifying for a president of the United States. If you can't accept the results of a legitimate election in the United States and you're willing to go to extremes to undermine the peaceful transition of power in the United States, then I don't think you should be allowed to run for president of the United States. So that to me is the one that I would want to go first and be tried first. But I don't think any of them is going to resonate with Trump's base. So I don't think it matters from a political perspective. You know, it's putting on my political scientist hat as opposed to my lawyer hat. From what I can tell from polling results and from the discussions around Trump's base and how they're reacting to all of these stories, it won't make any difference whether he's convicted or acquitted, which one he goes first. He's going to get the votes he's going to get.
Yeah, I mean, I agree that the federal January 6th case is, which to be clear, goes well beyond, it's not focused on that day. It's the entire, month's conspiracy is the one that, I think it is a very important question of like, when is it actually a good use of prosecutorial discretion to indict a former president? It's a very weighty act. It doesn't seem like a good political practice to be constantly indicting former presidents. It feels like, now we're moving into territory where whoever takes power, they just indict the last people. And that's not how you want to run a democracy, right? That's really bad. So there should be some, level of, let's be really careful before we, file an indictment against a former president. And maybe, some of the cases, I think it's arguable. To me, the January 6th case is an extremely strong case of that's the kind of thing that, if true, you really need to pursue an indictment for. You're undermining the peaceful transition of power. It's the foundation of our democratic system. What could be, bigger and worse than that for a president?
And honestly, it's such a strange case because it's like you look at the pattern of everything that occurred and everything that Trump did in the time period between the election and the certification of the results. And all of it is just like so knock you over the head, obviously bad. Like, to my mind, I'm speaking for myself, but I look at it and I'm like, oh my gosh, I can't believe he did all of that. I can't believe that this, that anybody would do this in the United States. We have such a long history of peaceful transitions of power, of people conceding election defeat and using legal means, but not these kind of crass political means to try to challenge when they think that election results are not accurate. And I look at it all and I'm like, oh, I'm stunned that any of it happened. And yet the criminal charges are difficult. It's not super obvious that any of it was a crime. I think that they did a good job putting together an indictment that looks plausible and good and strong and has a good chance of succeeding. But it is strange how difficult it was to construct a strong criminal case out of behavior that just looked awful and like something that should easily be indictable.
Okay, we are out of time. So I think we're going to call it. I'm sure we're happy to stick around and talk afterwards, but thank you all for coming. Really appreciate it.